For you to finish just one matter in the Supreme Court will take you not less than 6 years. And then, except for, obviously, election petition cases, this House is cognizant that the decentralization of the Supreme Court is sine qua non to a true federalism.
Decentralizing the power of the Supreme Court down to the state level is not the best solution.
Hello to you, our esteemed audience, and welcome to another enlightening episode of the Nigeria House of Commons TV show. Today we explore a legal dilemma that could reshape Nigeria's judicial landscape. Should we decentralize Supreme Court and extend its jurisdiction to all the states of the Federation?
Centralizing our appeal at the Supreme Court in Abuja leads to inefficiency and deny justice to litigants.
We are a nation with diverse persons, diverse cultural background, different. So there is this sense of unity if we have one Supreme Court. Why can't we just find to highlight the problem that's been tackling this institution and provide the lasting solution to it before we'll be talking about the decentralization?
It's a high-stake debate about efficiency, equity, and the soul of our justice system in the nation.
Madam Speaker, justice delayed is justice denied.
So sit back and enjoy perspectives that challenge, inspire, and could probably provoke you as well. So honorable members, let's bring the heat on.
Madam Speaker,
Nigeria, we hail thee, our own dear native land. The tribe and tongues may differ, in brotherhood we stand. Nigerians are and proud to serve our sovereign motherland. I pledge to Nigeria, my country, to be faithful, loyal, and honest, to serve Nigeria with all my strength, to defend our unity, and uphold our honor and glory. So help me God. Almighty God, ruler of heaven and earth, we beseech thee to inspire and guide all our counsels and actions, so that we may always walk in the path of justice, peace, love, and charity to one another. Help us with thy grace to do only those things that will promote unity, happiness, and prosperity of Nigeria. Amen.
Amen.
Honorable members, I have examined and approved the votes and proceedings from the last plenary. Honorable members, before we move into the next business of the day, I'd like to make an announcement regarding what happened during the last plenary. Honorable Justin Odinkalu made a statement that is unbecoming of an honorable member of this House. And Honorable Justin would kindly give tender and open apology to the Unity in Uniformity Party. Honorable Justin, you may rise to tender your apology now. Thank you.
Madam Speaker, honorable colleagues, I am Honorable Justin Odenkalo. I represent the good people of Eastern Heartland, Imo State. I arise to publicly tender my humble apology to my honorable colleagues from the other party, which is UUP. I so much say that I am so much sorry for my outburst. You know, when you are angry, you can say some certain things. So I believe that my apology is accepted by this honorable house.
Thank you, Honorable Justin, for your heartfelt apology. It takes a leader to take responsibility for wrongs, and it takes a great man to say sorry. Sorry is one of the most difficult things to say. Thank you, and I hope that the Unity in Uniformity Party would take his apology, accept his apology, and I also apologize on behalf of Honorable Justin and the UDP party for what happened during the last plenary. Thank you. So, honorable members, will move into the next business of the day. The next business of the day is a motion. The motion is the centralization of the Supreme Court to state jurisdiction. The motion is standing in the name of Right Honorable Abdulwahab Mohammed Yusuf. Honorable Abdulwahab is invited to kindly lead the debate on the motion.
Madam Speaker, the Speaker ordained by God and installed by men. My name is Right Honorable Abdulwahab Mohammed Yusuf, representing the Kingdom of Great Intellect, Kogi State. Madam Speaker, honorable colleagues, I rise this morning to move a motion on the need to decentralize the Supreme Court of Nigeria, as its current structure is no longer tenable in the administration of justice of the country. Madam Speaker, honorable colleagues, the House notes that the Supreme Court of Nigeria, established by the Supreme Court Act of 1990, and also by virtue of the provisions of the 1999 Constitution, the Supreme Court is a superior court of record and also the apex and the highest court of the land, in that where a matter is decided, you leave it to God from there. This honorable House is aware that the average litigant in Nigeria today, who has scaled through the hurdles of instituting or defending an action in court of first instance, say the High Court of Nigeria, of various states in Nigeria, then to the Court of Appeal, and then to the Supreme Court, is faced with enormous challenges with regards to assessing the Supreme Court of Nigeria, which is the apex court of the land. These challenges ranges from high cost of filing fees, the static location of the Supreme Court, which is only in Abuja, the Federal Capital Territory, and also the lean number of justices of the Supreme Court of Nigeria. I could remember under the regime of the former President Muhammadu Buhari, we only have 13, out of which there were supposed to be 21. We only have 13 justices administering justice to over 200 million Nigerians. Madam Speaker, honorable colleagues, the House is aware of the upsurge and backlog of over 5,000 cases currently pending before the Supreme Court of Nigeria, and the gestation period of one case in the Supreme Court today is that for you to finish just one matter in the Supreme Court will take you not less than 6 years. And then, except for obviously election petition cases that has a very short lifespan, this House is cognizant that the decentralization of the Supreme Court is sine qua non to a true federalism. If you are talking about true federalism today, then it is very, very important that cases should terminate, certain cases rather, should terminate at the state Supreme Court. And there's no need, except for just a few cases on constitutional matters, that should come to the Supreme Court at the center. And the House recalls that on the 12th day of July, 2023, My Lord Justice Peter Ige, a retired Justice of the Court of Appeal, Abuja Division, said, or he suggested rather, that the decentralization of the Supreme Court for more effective administration is necessary. He made that suggestion. And then the House should further recall that my Lord Honorable Justice Ayo Salami, PCA, former President, Court of Appeal, who was unceremoniously relieved of his duties by the then President in 2011, President Goodluck Jonathan, said that the rot in the nation's judiciary may be traced to the over-centralization of the judicature or the hierarchy of superior courts in the country. The House will further note that the current structure of the Supreme Courts, the House is worried that the current structure of the Supreme Courts at the center is a recipe for injustice. It's a recipe for anarchy. It's a recipe for the desecration of the rule of law. The House should further note that if the Supreme Court, as it stands, is constitutionally allowed to have only 21 justices. Only 21 justices. Honorable colleagues, Nigeria today is blessed with about 36 federating units, 36 states, 109 senatorial districts, and 360 federal constituency. Having only 21 honorable justice, learned jurists of the Supreme Court to administer justice to over 200 million people. Honorable colleagues, is this not a recipe for injustice and anarchy?
It is.
Honorable colleagues, if we should allow this to remain, I think strongly that it is a recipe for anarchy and a breakdown of law and order. How do you expect a justice of the Supreme Court who hails from, say, Cross River State, to be able to administer laws bordering on native law and custom of the people of Ida, Ofu, Ibaji, and even another area of Kogi State? How is that going to be possible? Because he may not really have knowledge about it. But the diverse nature of the country requires that these things, this Supreme Court should be brought closer to the people, so that people knowledgeable in those facts should be meant to administer on them. In the Supreme Court today, we have justices that rose from Sharia court, area court, up to the Supreme Court today, administering justice on issues bordering on constitutional law matters, and which is not right. On this note, the House resolves as follows: the House resolved to establish in each state of the Federation, to establish a Supreme Court in each of the 36 states of the Federation, mandates the National Judicial Council to recommend names of legal practitioners, qualified legal practitioners, for appointment to those courts to be created, and then mandates the House Committee on Judiciary to ensure compliance. Madam Speaker, honorable colleagues, this is my humble locomati and the locomati that I've made without love or passion. Thank you very much.
Thank you, Honorable, Right Honorable Abdul Wahab. Your last words reminded me of Honorable Patrick Obayagun.
It's my political
Apparently so. Thank you, Honorable Abdul Wahab. Any seconder to this motion? Honorable Mary.
Madam Speaker, my honorable colleagues, my name is Mary Victor Magaji, representing the most equitable people of Kebbi State. Madam Speaker, I rise today in support of the motion presented by my honorable colleague, Right Honorable Abdul Wahab. Madam Speaker, to start with, the administration of justice rests on two basic pillars: Nemo Judex Inconsesqua and Audi Alterum Patem. And these two principles simply mean that justice must not just be done, but that justice must be manifestly seen to be done. Madam Speaker, justice delayed is justice denied. The Supreme Court, as we have it, is a court of enumerated jurisdiction. And that is why the scope and the number of justices are provided for by the Constitution in Section 232 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. However, Madam Speaker, as at today, we don't even have up to 21 justices in the Supreme Court. If my memory serves me right, we have just about 15 to 16 justices at the moment, sitting in the apex court and determining the fate of over 200 million Nigerians, as my honorable colleague has spoken. Madam Speaker, if we choose to decentralize the Supreme Court, just as we are proposing, Madam Speaker, is going to bring some advantages. First of all is the improved expertise of the state Supreme Court. Madam Speaker, state-level Supreme Courts could help in developing specialized expertise in handling local issues, such as land disputes, say chieftaincy matters, marriages, or even environmental concerns that are specific to each state or region. Madam Speaker, it could also help with enhancing accountability because, Madam Speaker, if we choose to decentralize, decentralization could now help state governments understand that they are solely responsible for administration of justice within their jurisdictions and constituency, and that will enhance accountability. Madam Speaker, also, there are precedents that we can follow. We principally adopt our legal system from the United States of America and the United Kingdom. And if we're going to be following them, Madam Speaker, we know that they don't have just one central apex court in determining their matters. Madam Speaker, back here in Nigeria, we already have some institutions that we have decentralized, such as the anti-corruption agencies. And these institutions demonstrate that if we decentralize our legal system, our Supreme Court is going to help effectively in good governance and accountability. Madam Speaker, these are my humble opinions in respect to the topic at hand. I humbly submit. Thank you, Madam Speaker, my honorable colleagues.
Thank you, Honorable Mary. You speak so soothingly. I can listen to you speak all day. Any opposition to this motion? Honorable Abdulkarim Garba.
Madam Speaker, my honorable colleagues, my name is Honorable Garba Abdul Karim. I represent the good people of Bauchi State. Madam Speaker, I rise to oppose the motion decentralization of Supreme Court to the state jurisdictions. Madam Speaker, decentralizing Supreme Court will solve the problem earlier mentioned by my honorable colleagues in the House. Madam Speaker, on the 12th July 2023, a retired justice of the Abuja division of the Court of Appeal, Justice Peter Ige, sorry if I did not pronounce the name well, he suggested decentralization, but some senior lawyers among his midst were against this motion raised by him. On this issue, the senior lawyer Professor Sam Eruga, sorry if I not pronounce the name well, said there cannot be more than one Supreme Court because it is the highest court of every country in every country. Madam Speaker, he stated that if the Supreme Court was decentralized, saying that the regional level, the country would be losing its benefit from diversities. Madam Speaker, the question should rather be employing and appointing more justice, not decentralizing. There are so many issues which were supposed to be, raised and discussed here. Not decentralization of Supreme Court. Supreme Courts are doing their best to see that our country moves fine. Thank you, Madam Speaker.
Thank you, Honorable Abdul Karim. Any other opposition to this motion? Honorable John Bernard.
Good morning, Madam Speaker, my honorable colleagues. I am John Maduka Bernard, representing the good people and loving people of Ebonyi State, and I am here supporting my fellow colleague by opposing what UDP are proposing the decentralization of Supreme Court to state jurisdiction. It's important. It's somehow funny or coincidentally, the person that raised this motion is a learned colleague. And I believe he should be abreast what our Supreme Court means, the glory it carries. This is the apex court in the land. And I know you are abreast with what the Constitution provided for Supreme Court, the jurisdiction that it carries. He said it will foresee appellate cases and original cases. And also in line with that, it talked about cases between state and states, and then federal government. Madam Speaker, it's quite will I say challenging or disturbing to suggest that states should have Supreme Courts. I heard him say state having Supreme Court, and then if there are other cases that would they can't handle, it goes to the center. Does that suggest, I'm just thinking, does that suggest we should have two kinds of Supreme Courts? Because it means if all the 36 states were to have their Supreme Courts, and then there are cases between two states, let's say land dispute or land border, where does that kind of case goes to? Does it go to the one in the central? So that suggests that we have two kinds of states. And then I begin to ask myself, what happens to precedents? What happens to interpretation of our law? What happens if it goes to the center, Honorable Adwahab, if it goes to the center, and then we have states? Are we saying the state Supreme Court will be lesser to the central? Then what's the essence of the apex court? What's that quote? That unity, that uniformity. Madam Speaker, I have few points I actually listed out here. I will just read them through, and then I'll see, because of want of time, I'll just be picking them and see if I could deliver every one of them. There is the problem of inconsistency if we have decentralization of our Supreme Court, because you'll be having interpretation of laws in different regions as they feel it should be interpreted. Like what we had in the recent election matters. We have many persons believed the case would have tilted to a certain dimension. Then we have our Supreme Court judges gave verdict. Even in the verdict, their verdicts were varying. You will not have five, let's say if you have 5 judges, you will not have 5 of them interpret the same thing exact. There's tendency that you have variation. So if we have decentralized Supreme Court, there's a tendency of having inconsistent legal precedent. Then we have, it weakens our unity. Madam Speaker, it's important also to stress at this point that we are a nation with diverse persons, diverse cultural background, different. So there's this sense of unity if we have one Supreme Court. If there's anything you feel aggrieved, you go to the center and go and resolve it. Then we have weakening role of Supreme Court in constitutional matters. As I said earlier, you will find out that our constitution will be weakened because you have varying interpretation. Then the provision of our constitution, the way they interpret it, you find out that everything is watered down. Proximity has a way of removing prestige that the Supreme Court has. When you take it too close to the people, there's this prestige that the Supreme Court has when you feel aggrieved in the state level or even the federal state high court level, go to this, and then when you go to, there's this sense of this the highest. So when you bring it down to state, it waters down that essence, and then we lose that. Then we have increased political influence. Then you see the problem of, let me even point out, if I forget, decentralization will not stop the backlog we have in our Supreme Court. It will not stop, and this is my point. It's not like all the case, our original case that goes to the Supreme Court, all the whole case that goes there are not original cases. There are cases that are built up through the system. We have customary court and stuff, high court, appeal courts. If we are to be right with our way of thinking or what we are thinking about this, we should be looking into what interpretations of our constitution, how cases are being interpreted in this lower court, instead of looking up there and thinking that decentralization will solve the problem of backlog, because even at that we still have this same issue. So backlog of cases is not the issue for bringing up decentralization. Thank you, Madam Speaker. Thank you
very much, Honorable John Bernard. I'd like to make a comment regarding something that you just said. You mentioned that the Supreme Court, that most cases that are done in the Supreme Court or are treated in the Supreme Court usually arise from inferior courts. I'd like to bring to your attention that Section 231 of the Constitution of the Federal Republic of Nigeria 1999 as amended provides expressly that the Supreme Court has original jurisdiction and appellate jurisdiction. And then I think the subsection also points that there are some matters that the Supreme Court has original jurisdiction where it is conferred by an act of National Assembly. So I'm pointing that out so that the House can be guided. All right, thank you. Any other honorable member in support of the motion? Honorable Abdullah.
Madam Speaker, my honorable colleagues, my name is Abdullah Isani and I represent the enterprising and industrious people of the Center of Commerce, Kano State, Kanawandabu, Kodamekazu, and Fika. I stand before this Honorable House of Commons to support the motion that was raised by my honorable colleague, Honorable Abdul Wahab, on the need to decentralize the Supreme Court as it is presently into state jurisdictions. Before I go forward, I want to correct a notion that was brought up by my honorable colleague, Honorable Bernard. Honorable Bernard, you made mention that when somebody is not pleased or when somebody feels that they don't have opportunity of winning a case in a state, they can move their case to a state whereby that is what we have in place presently. And by the time we decentralize it, you cannot move a case that happened in a state to another state.
Exactly.
No, you cannot. When something happens in Abuja, when a crime is committed in Abuja, it should be treated in Abuja. You cannot move it to Sokoto because the judge there is in your pocket. So, decentralizing the Supreme Court to state jurisdiction is essential for improving judicial efficiency, access to justice, and inclusivity. Milords, the World Bank 2022 emphasized that judicial efficiency is crucial for attracting investment and fostering economic growth. Delays in resolving business disputes discourage investment and economic activities. The centralized court will resolve commercial disputes faster, creating a conducive business environment. Lagos State established its multi-door courthouse to handle alternative dispute resolution efficiently, fostering business confidence. Ghana Regional Court also expedites commercial cases, enhancing investor trust. My state, for example, Kano State, the center of commerce, we are business conscious. We have the Sharia industrial layout. We make our laws in such a way that we will attract investors. If your state is fond of flaunting laws and driving away investors, my state will make our laws in such a way that investors will have confidence in the rule of law, and they will be attracted to come and do business in my state. Madam Speaker, my honorable colleagues, as of 2022, the Supreme Court of Nigeria had a backlog of over 35,000 cases.
You can imagine. Thousand.
With delays lasting up to 8 years for some cases. This is according to the Nigerian Bar Association, the NBA. Centralizing our appeal at the Supreme Court in Abuja leads to inefficiency and denied justice to litigants. Just as my honorable colleague, Honorable Maurice, have stipulated earlier that justice delayed is justice denied. Centralizing the Supreme Court would reduce case backlog, enabling quicker resolution. The Federal High Court in Nigeria, located in various states, handles specialized cases such as maritime and electoral matter, significantly reducing pressure on Abuja. Similarly, the U.S. has federal circuit courts that manage appeals regionally, easing the burden on the Supreme Court. The states already have an appeal court that are handling some cases. If we the honorable members, give this motion the necessary support that is required, the political will that we have, we guarantee this state will give them more power to be able to try these cases independently, whereby the Supreme Court will only serve as overseeing. Another issue which my colleagues have already mentioned before is access to justice. Imagine traveling from your state to come to Abuja for a case, and God forbid you get kidnapped on the way. Or you are involved in an accident. Look at the bad roads all over the country. But if the Supreme Courts are in the state, we will reduce these incidents to a great extent.
Thank you, Honorable Abdullahi. You have 30 seconds to round up.
Yes, ma'am. In India, decentralization has established regional high court in major states, improving access for citizens. I've heard people severally complain that they travel to come and attend a case and the judge is not on seat. Without prior communication, your money, all the risks that you take, everything is wasted. So, Madam Speaker, honorable colleagues, I urge us all to give this motion that was raised by Honorable Abdul Wahab the necessary support and ensure it scales through so that our states can have the power to determine the peculiar cases that is common to them.
Thank you, Honorable Abdullahi. Thank you very much. You have spoken so passionately. Any other honorable member in opposition to this motion? Honorable Olanrewaju.
Madam Speaker, honorable colleagues, I rise this afternoon to against the motion which was early moved by my honorable colleagues, Honorable Abdul Wahab.
Point of order. Honorable Oluchi, point of order.
From order 9, Madam Speaker. Madam Speaker, honorable colleagues, I am Honorable Oluchi Rosanna, representing Anambra State. Madam Speaker, Honorable Olanrewaju, we don't know you, we don't know your constituent. Thank you.
Other honorable colleagues. Honorable Manuchi, your point of order is sustained. Honorable Olanrewaju.
Madam Speaker, I've not started a expatiate or to talk about the motion that I was against it. I should have expect her to let me land before raising another. Actually, the point of order that she raised is very important, but she should have allowed me to land before raising that order.
All right, thank you. Other honorable colleagues. Honorable colleagues. Honorable Olanrewaju, the procedure is to introduce yourself to the House and let us know your state.
Madam Speaker, there is different way you can express and explain yourself.
All right.
And the time I'm still on my tentacle, so it should have allowed me to land before she raised the order.
All right. Honorable colleagues.
There is no law that said you is a must. I stand to be corrected, Madam Speaker. There is no law that emphasizes that is a must for you to mention your name immediately you stand up. Get me right.
Honorable Olanrewaju. According to the standing order of this House, the first thing to do is to introduce yourself to the House and let us know your state.
Madam Speaker.
Honorable Olanrewaju, please, there will be no further comments regarding this.
There should be.
Kindly introduce yourself and let's proceed. Thank you.
Madam Speaker, honorable colleagues, this is Honorable Timothy Olanrewaju, the Honorable representing the good people of Lagos State. Madam Speaker, I rise this afternoon to against the motion which was early moved by my honorable colleagues, Right Honorable Abdul Wahab. Madam Speaker, I think this motion is very important. And in another way, we should not try to create problem when we are trying to solve the problems. It is obvious and it is important for everybody to know that there is a lot of issues that surround the issue of the judiciary system in this country. And we all know that the judiciary system in Nigeria is not as effective as the way it's supposed to be, which shows that we need to work on the efficacy of that institution. But Madam Speaker, honorable colleagues, I think decentralizing the power of the Supreme Court down to the state level is not the best solution. Why can't we just find to highlight the problem that's been tackling this institution and provide the lasting solution to it before we'll be talking about the decentralization? Madam Speaker, honorable colleagues, we have the Supreme Court happen to be the apex court as far as this Federal Republic of Nigeria is concerned. We have the Court of Appeal. Out of the 36 states that we have 20 Court of Appeal, which plus the headquarters that was in Abuja here. And we also have the High Court. Now, Madam Speaker, honorable colleagues, Honorable Abuja move a motion for decentralizing by make sure that each 36 states have their own Supreme Court. Madam Speaker, when we are talking about the issue of, one of the reference that my honorable colleagues made mention is the issue of backlogged. And we should have asked ourselves what causes the issue of backlogs. Is that something that we can find solution to? And the answer is yes. My honorable colleague made mention of the issue of having 21 judges. That is what the Constitution provides, that there must be 21 judges at the Supreme Court. But today, they said we are having 13 judges. What are the delays? What is causing the federal government not to do the needful? I think that's some questions that we need to ask ourselves. Now, having this issue, I think it is the right time for us to ask either the President and the National Judiciary Council for what is causing the delay that makes them not to appoint, to send the mail to the President and then to the President to the lawmaker for better for approval. Now, when we are talking about let me highlight some problems that have been facing these sectors. We are talking about the backlog of cases, inadequate funding resources, corruption within the judiciary, political influence, interference, inconsistent of legal precedent. Now, solution, judiciary reforms. I will expect my honorable colleagues to make mention of judiciary reforms, which is going to solve the whole problem, not the Supreme problem alone. There is a lot of problem that have been tackling the Court of Appeal and the High Court, which we all know. And this issue of backlog is not happening to Supreme Court alone. It affected all the judiciary system in Nigeria. Now, for us to be finding the solution to the problem that is affecting the Supreme Court and left the other court, Nigerian system alone without even talking about them, are we solving the problem of this country, or we are adding to the previous one? Now, Madam Speaker, this is the solution. I expect we need to affect in the way of these judiciary reforms. I think there is a need for us to have maybe there must be an amendment in the Nigerian Constitution, or the House should work on we can give the march order to the judiciary system, in the sense that, I could remember in 2013, let me take for instance what happened in Osun State during the Aregbesola and Oyinlola case. They spent nothing less than 3 years. They are going to the High Court, from High Court down from tribunal to the Appeal Court, from Appeal Court down to tribunal. Now, until 2010, I think that's July 27, before they now give the final verdict on that. Now, when we move to 2019, there is a little bit change. And what are the changes? They made an amendment that there must be a certain date that the cases must spend at the Appeal Court, at the tribunal and the Supreme Court. Since that time, there is no delay. There is no delay. If we can achieve that on election cases, why can't we achieve that on the normal cases? Now, if there is a need, we have 21 judges. That is what the Constitution provides. We can still increase the numbers of. If we try to just make sure that we decentralize the power of the Supreme Court, it means that the prestige that Supreme Court have is not there again. Don't forget that there will be a contradicting judgment. Yes. Let the House may recall what happened in the Rivers State. Because of a recent, why someone will collect the court of order here, and another court of order will come from another system. We are not trying to.
we don't try to find the solution to that problem, and we are now trying to create and decentralizing the Supreme Court down to the lower level. And we all know, Madam Speaker, and we all know what has been happening in each state before now. The way each governors are influencing even not only judiciary system, if now bringing Supreme Court down to their doorstep, which means that some of them will make sure that they will torment their citizens, they will torment whosoever that is not following them, and then we are trying to make sure that the masses, which judiciary happen to be the last hope for the common man, but at the end of the day, the type of result that we are expecting, we will not get it. Madam Speaker, it is because of the time. I have a lot of things to say to back my point up, but I will plead to my honorable colleagues that instead of us to be asking for decentralization, why can't we just clamoring for the judiciary reform? Thank you, I so sorry.
Thank you. Thank you very much, Honorable Olarewaju. At this point, I would invite Honorable Abdulwahab Muhammad Yusuf to give a final remark on this motion. Thank you.
Thank you very much, Madam Speaker, my honorable colleagues. My name, Right Honorable Abdulwahab Muhammad Yusuf, from the Kingdom of Great Intellect. I represent Kogi State. My honorable colleagues, by the grace of God, I am a legal practitioner, a solid one at that. I practice law at all the spheres of the courts in Nigeria. By the grace of God, today I have appeared before them, and to the glory of God today, I'm a honorable member. If at the end of my tenure, my constituent did not find me worthy to remain here, I'll go back and dust my wig and gown. You will go back. Continue my legal practice. You will continue. The point I'm making is, we are not talking, decentralizing the Supreme Court itself, in itself, is a part of judicial reform. I would have agreed with my honorable colleagues from the opposing side that maybe it is not a holistic reform. To conclude a matter in a high court, for instance, today, if the counsels in that matter are very serious, it will not take more than 8 months to conclude a matter. I have done it before. And the highest my cases have taken in a high court is about 18 months. Is this the same for a court like Supreme Court of Nigeria, excluding election matters that has timeline? Honorable colleagues, what are we saying? Is this how we want to continue? No. Why are we scared? Why are we scared of change? Why are we scared of reform? Should we be talking about prestige or justice? Exactly. These are two different things. You want to maintain the prestige of the Supreme Court because of the name Supreme, and then injustice everywhere. My colleagues were telling me about a case he inherited from all the parties, the original parties in that matter. They all died. The matter was instituted as far back as 1989. The father died. The elder brother was substituted. The other brother died. Now the son, the children are currently the ones. A land matter, for that matter. What is a land matter doing in the Supreme Court? Why can't we have regional state Supreme Court that will determine the fate of land matters? Or you talk about chieftaincy disputes. For God's sake, what is the business of a serious country, a serious Supreme Court? What is their business when in chieftaincy matters? When we have matters on constitutional reform, matters bordering on fundamental human rights, that could be interpreted. And there's actually no room for foreign shopping, because the jurisdiction of these courts, Supreme Courts of the states, will be identified, delineated, and differentiated from the Supreme Court at the center. The Supreme Court at the center could just, in a federating unit like ours, or like Nigeria, all the federating units are the same. That is true federalism. So there is no superior court when you talk about in a true federalism. When this decentralization is done, you cannot say the Supreme Court at the center is supreme to this is higher in hierarchy to the Supreme Court at the lower. at the state.
No, it's not.
Because of the nature of the cases, they will be meant to handle.
Exactly.
We have the High Court today and the Federal High Court. They are not handling the same matters, but they exist side by side. They know their onions, they know their limits, and they will never cross it. So, honorable colleagues, I will end on this note that yes, I'll end on this note by saying that my Lord Justice Chukwudifo Okunye-Aputa, Justice of the Supreme Court of Nigeria of blessed memory, of the Supreme Court, speaking the Supreme Court, yes, speaking through my Lord Justice Oputa in the highly celebrated and notorious case of Adegoke Motors Limited versus Dr. Babatunde Adesanya, said that we are not the final because we are infallible, but we are infallible because we are the final.
Thank you.
So on this note, I also say that our ability, honorable colleagues, to reach unity in diversity is a true test of and the beauty of our civilization.
Thank you, right,
so, honorable colleagues, I urge you to give your support to this motion. It's the only way that we can test our diversity as a nation. Thank you very much.
Thank you. Honorable, right, Honorable Abdulwahab. I'll invite the fact checker to kindly set the record straight.
The very delectable and erudite speaker of this honorable house,
Honorable Justin,
very distinguished members of the Nigeria House of Commons, arise to state the facts as it were. The first speaker in the person of Right Honorable Abdulwahab Mohammed Yusuf, in his opening remark, made a claim that under the presidency of President Muhammadu Buhari, there were 13 justices. The verdict for this claim is no reference, therefore misleading. There were significant judicial appointments and actions during his administration. For specific number of this list of justices, additional research beyond the current sources is needed. The second speaker, in the person of Honorable Mary Victor Magaji, in her commentary, made a claim that Nigeria has 15 to 16 justices, and the verdict for this is incorrect. As of October 2023, Nigeria Supreme Court has a total of 10 justices, which is the lowest number in its history. The Supreme Court is constitutionally allowed to have up to 21 justices, but has not had its full complement for many years. The third speaker, in the person of Honorable Abdul Karim Garba, made a claim that on the 12th of July 2023, Mr. Peter Ige suggested Supreme Court decentralization. The verdict for this claim is correct. On the 12th of July 2023, retired Justice of the Abuja Division of Court of Appeal, Justice Peter Ige, suggested the decentralization of Supreme Courts in Nigeria to improve administration and administration of justice. Beg your pardon. And the fourth speaker, Honorable John Maduka Bernard, did not make any data-related claim. The fifth speaker, in the person of Honorable Abdullahi Sani, made a claim that World Bank in 2022 posited that judicial efficiency makes for better business environment. The verdict for this claim is correct. He went on to make another claim that Nigeria had over 35,000 backlog of cases. The verdict for this is more citation needed. The backlog of cases was noted to be a critical issue, reflecting a broad challenge within Nigeria's legal framework. However, no figures have been verified. And then he went on to make a claim that over 70% of Nigerians live far from Abuja. The verdict for this is correct. And also finally made a claim that Nigeria has over 250 ethnic groups. The verdict for this is correct. The sixth speaker, Honorable Timothy Olarewaju, made no data-related claim. And I beg to take a bow at this juncture. Thank you very much.
Thank you very much, fact checker. At this point, I would invite some of our guests to give comments on this matter. First, I'd like to invite Prince Oriri Richard, who is a senior legislative aide on strategy to the Speaker of the House of Representatives. Mr. Prince Oriri Richard, please, you have the floor in a few minutes, sir. Thank you.
Honorable Speaker, like you rightly said, I am Prince Oriri Richard, Senior Legislative Aide to the Honorable Speaker, House of Representatives. I've listened very carefully to both the lead speaker and the opposing team in this debate. And sincerely, I want to commend the two groups for what they have done so far. On the issue of Supreme Court, decentralization of the Supreme Court, they have both spoken so well. But we operate a democratic system in Nigeria, and we have three arms of government. And these three arms of government, the executive, the judiciary, and the legislature. If you come to Abuja, you see the called one session of FCT, the three arms zone. And the Supreme Court, not that sincerely, it's not that the Supreme Court, they are not adjudicating cases in the way and manner it should be. Most of the problem emanating from this issue of time or backlog of cases on ground before the Supreme Court, I think I can push that blame basically to the lawyers. Most times, there's no time that you go to the Supreme Court and you not see judges seated. But lawyers will come with frivolous excuses. My client or this is no chance and all of that. And at the end, they will plead for longer time. And the court will have no other option than to give them the time. And that is what is actually causing most of those problems. And going to the issue of decentralizing Supreme Court to the 36 states of the Federation. Now, currently, the country is fighting so hard for funds. Of recent, the president submitted another proposal for borrowing, just to borrow money to enable him run the country effectively well. And if you are decentralizing the Supreme Court to the 36 states of the Federation, you talk of infrastructure. You talk of recruitment of more judges. And the 21 judges of the Supreme Court as approved by the Constitution of the Federation today, I think it's enough. It's enough. What we should be doing, what we should think, the angle we should be thinking towards reforming the judicial system, especially the Supreme Court presently, should be when they are sitting, there are certain things that the court needs, but they don't have. We should equip them to have such like a recording machine. Instead of writing manually,
It gives judges stress. And in Nigeria, hardly you go to court that you see recording machines. Manual handling of cases, I think, is another serious problem. So on this note, I will beg to support the opposing side to the decentralization of Supreme Court. Honorable Speaker, thanks for what you are doing for Nigeria, and I appreciate the way and manner you are handling this honorable house. Members, you are doing very well. Well done.
Thank you very much, Prince Richard. It's a pleasure to have you in our midst today. We have Dr. Obayomi Olukayode Gregory, who is a political economist, security and international relations expert. Dr. Obayomi is invited to share his opinion in a few minutes. Thank you, sir.
I'm Dr. Obayomi Olukayode Gregory, a political scientist, political economist, international relations expert. I've listened attentively to all the speakers, both on the pros and on the cons side, and I must confess that I really enjoyed the discussion. These are budding politicians, I suppose, but my admonition would just be that we shouldn't be like our age group who are there now. So when we get there, we should do the best for Nigerians, because our generation has not really been doing well. I must confess that. So after that admonition, I want to say that now for me, I want to stand in between the two contending parties. Stand in between because there is the need to protect the honor and prestige of the Supreme Court. There's also the need to bring justice closer to the people. Let's have regional disintegration or decentralization of the Supreme Court. Because I have a case in court as I stand. Since 2022, we have not even started hearing. June 2022, we have not started hearing. Like he said, lawyers will come with different excuses just to, those who don't have good case, they want to prolong the case so that you don't get to the end at the end of the day. He said it. So, but for, you see, they said the judiciary is the hope of the common man. As somebody said, most of the common people in Nigeria are in the rural areas. I think 70% is said, according to the statistics you supported. So if we have people mainly at the subnationals, at the local level, we should try and bring justice closer to them. Like he said, he had a very good argument that some people will be coming to Abuja for judicial process. Some of them die in accidents. I've experienced that before. So when it's closer to them, there will be good accessibility, and the Supreme Court will even be more efficient, and they can attend to more cases, but not at the state level. If you bring it to the state level, it's like you are useless in the Supreme Court. Every state, there will be contradiction, there will be counter motions, counter injunctions, and too much politicization. So don't just bring the Supreme Court, say Supreme. What is Supreme if it's in every state? It's not more Supreme, it's a state court. I don't know what to say. So I'm standing in between the two groups that we should go for regional structures so that it will be closer, to be more accessible to the people. Then at the same time, you can still maintain that level that is supposed to be in order to kind of give it kind of a recognition. You know, what is not available will be respected. Yes. If it's available everywhere, it becomes useless. Yes. And I think that's going to help our system.
Thank you.
In addition, I want to congratulate you all. Like I said, my admonition is that when you become real politicians, please let us help Nigeria, because we are not doing well, frankly speaking. We are not doing well. But I believe there is hope for this country. Thank you very much.
Thank you very much, Dr. Obayomi. Honorable members, the decision to decentralize the Supreme Court is a sensitive one which would require careful consideration of the potential benefits and drawbacks, as well as the development of a comprehensive approach to address the challenges faced by the Supreme Court, and ensure the effective delivery of justice. The Supreme Court is the apex court in hierarchy and the most superior court of record, which was created by Section 230 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The Constitution confers on the Supreme Court the original and appellate jurisdiction, and the rationale behind setting up courts in the first place, whether Supreme Courts, High Courts, Federal High Courts, National Industrial Courts, is for the citizens to have access to justice and to uphold the rule of law. However, if the Supreme Court still has over 5,000 backlog of cases, can we say that the current system of the Supreme Court allows for access to justice of Nigerian citizens? It is pertinent to note that the decentralization of the Supreme Court does not affect the superiority of the Supreme Court. The decentralization of the Supreme Court only insinuates that the Supreme Court will begin to have judicial divisions, just like the Federal High Court, just like the Court of Appeal and Federal High Court, National Industrial Court, and the likes. They have judicial divisions in different states of the Federation. So decentralizing the Supreme Court does not have anything to do with reducing the superiority of the Supreme Court. It's just to ensure that the Supreme Court is accessible to every Nigerian citizen. And to ensure that, and this will also ensure that the Supreme Court will still remain apex, regardless where the Supreme Court sits. The centralization of the Supreme Court, however, will ensure improved understanding of local dynamics, as state Supreme Courts may have a better understanding of local customs, laws, and dynamics, enabling them to make more informed decisions. It would also increase the accessibility to citizens, particularly those in rural areas who may have faced significant challenges in accessing the current centralized system of the Supreme Court. Conclusively, the essence of our representation as honorable members is to ensure that justice is done to the people of our various constituencies, and that we do all that we can in our power to ensure that the people have access to justice, and that the right to access to justice of the citizens of Nigeria is protected. So, honorable members, the motion before us once again is decentralization of the Supreme Court to state jurisdiction. Those in support of the motion should say aye. Aye. Those against the motion should say nay. Nay. The ayes have it. Honorable Oluchi, kindly move motion for adjournment of this meeting.
Madam Speaker, honorable colleagues, I am Opara Oluchi Rosanna, representing the light of this nation, Anambra State. I move for the adjournment of plenary to a later date as agreed by the House. Thank you.
Thank you very much, Honorable Oluchi. Honorable Abdulkarim, kindly second adjournment.
Thank you very much, Madam Speaker. My name is Honorable Garba Abdulkarim. I represent the good people of Bauchi State. I second the adjournment. Thank you.
Honorable colleagues, the motion before us is whether or not this plenary should be adjourned to the next legislative dates as agreed by the House. Those in support of the motion should say aye. Aye. Those against the motion should say nay. The ayes have it. Arise.
Today's debate peeled off layers of a complex issue: whether decentralizing the Supreme Court system in Nigeria would lead to swifter justice, or could it be a threat to our national integrity? Opponents, which made up members of the UDP party here in the Nigeria House of Commons, argued that decentralizing the Supreme Court in Nigeria will lead to improved accessibility for the common man, swifter justice delivery system, and more attention to local issues. However, Proponents, which made up members of the UUP, insisted that decentralizing the Supreme Court could lead to inconsistencies in ruling, weakened judicial authority, and threatened national cohesion. Regardless of what the actions we have here today, one thing is certain: justice belongs to us all, and the future of justice is not one man's business. We say a very big thank you to our esteemed honorable members, to you, our amazing and attentive audience, and of course to Africana League for shining the light of discourse so high. Until next time, stay engaged, stay informed, and always remember, you too are a part of this story. My name remains Ifunanya Nduka. Bye.